You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. Cloud contracts and service level agreements, or SLAs, are more than legal paperwork. They are enforceable definitions of obligations, remedies, and evidence. In essence, they translate trust into specific commitments. Where marketing brochures promise reliability, contracts demand accountability. For customers, these agreements provide recourse when providers fail to deliver. For providers, they define boundaries, clarifying what is promised and what lies outside scope. Without contracts, organizations must rely on assumptions, which seldom hold in disputes. An SLA that commits to 99.9% uptime means the difference between a vague guarantee and a quantifiable measure backed by service credits or remedies. These instruments make cloud relationships predictable, auditable, and legally defensible. They remind all parties that cloud adoption is not just a technical decision but a contractual relationship, where expectations, roles, and consequences must be defined in black and white. A Master Service Agreement, often abbreviated as MSA, establishes the overarching terms that govern cloud usage. It functions as the umbrella contract, setting definitions, order of precedence, and legal frameworks that apply to all related documents such as statements of work or service addenda. The MSA typically covers issues like indemnification, liability limits, intellectual property, and dispute resolution. Without it, individual agreements risk inconsistency or contradiction. Think of the MSA as the constitution of the cloud relationship. It provides foundational rules upon which all other clauses rest. For example, if an SLA specifies an uptime metric but the MSA defines how remedies are calculated, the MSA ensures consistency across services. Customers negotiating MSAs must pay close attention because subtle language can tilt responsibilities. A well-structured MSA balances provider flexibility with customer protections, ensuring neither party faces unbounded risk. Statements of work, or SOWs, and detailed service descriptions add specificity beneath the MSA. These documents define the scope of deliverables, dependencies, and in-scope features for a particular project or service. For instance, a SOW for a managed database service may list setup activities, supported versions, and backup responsibilities. Service descriptions clarify what is included and what is excluded, so customers understand where obligations begin and end. Without these details, disputes easily arise when expectations diverge. This is much like hiring a contractor for home renovations. The general contract outlines principles, but the SOW specifies whether painting the trim is included. In cloud, SOWs prevent misunderstandings by documenting precise responsibilities. They also provide reference points for measuring performance. When conflicts occur, these documents often become the most cited evidence in resolving whether obligations were fulfilled or overlooked. The shared responsibility model is a central clause in most cloud contracts, allocating control ownership between provider and customer across different service layers. Providers may take responsibility for physical infrastructure security, while customers retain control over data, configurations, and identity management. This clause eliminates the dangerous assumption that the provider covers everything. For example, while a provider may ensure hypervisor patching, it is the customer's duty to configure access policies. The shared responsibility model functions like a lease agreement. Landlords maintain building integrity, but tenants must lock their own doors. Contracts explicitly documenting these allocations reduce ambiguity and reinforce accountability. Without such clarity, breaches can lead to finger-pointing and unresolved liability. Customers must read these clauses carefully, as misinterpretation often leads to compliance gaps. The shared responsibility model transforms vague notions of security in the cloud into enforceable role definitions. Confidentiality clauses and non-disclosure agreements safeguard trade secrets and sensitive operational data. They ensure providers cannot use or disclose customer information outside agreed purposes, and that employees handling such data are bound by confidentiality obligations. These provisions are crucial when organizations entrust intellectual property, proprietary algorithms, or sensitive customer records to third-party platforms. Breaches of confidentiality not only harm reputation, but may also create competitive disadvantages. An NDA is like a lockbox. It guarantees that what is placed inside remains unseen without authorization. In cloud contracts, confidentiality extends beyond casual promises, requiring providers to maintain legal, procedural, and sometimes technical measures such as restricted access or encryption. Effective confidentiality provisions also include carve-outs for required disclosures under law, ensuring compliance with legal obligations while protecting customer interests. Without these agreements, customers risk exposing critical assets without enforceable recourse. Data processing agreements, or DPAs, are particularly critical where personal data is involved. They codify the controller-processor relationship under laws like the GDPR, setting lawful bases for processing and privacy obligations. The DPA specifies responsibilities for data subject rights, breach notifications, and retention periods. For example, it may state that the provider will process data only on documented instructions from the customer. DPAs also require subprocessors to be bound by equivalent protections. Think of a DPA as a subcontracting clause in construction. If work is outsourced, the same standards must follow. Without a DPA, organizations risk non-compliance with privacy laws, potentially facing heavy penalties. DPAs ensure providers acknowledge their legal roles and commitments, giving regulators and customers confidence that personal data receives lawful and transparent handling across the service chain. Subprocessor disclosure and approval rights extend DPAs by requiring providers to reveal which third parties they use to deliver services. Customers may also have rights to approve or object to new subprocessors, with providers obligated to give advance notice. This transparency prevents sensitive data from flowing to unknown or unvetted partners. Imagine trusting a contractor only to find they've secretly subcontracted critical work. You would demand disclosure. Subprocessor clauses function similarly, ensuring customers are not surprised by hidden dependencies. They also set notification timelines, allowing customers to react before changes take effect. Without these provisions, data may traverse unexpected jurisdictions or vendors, creating legal and compliance risks. Subprocessor oversight balances provider efficiency with customer control, preserving trust and accountability in distributed service models. Data residency and localization terms commit providers to store data within specified jurisdictions or regions. These clauses are essential where regulations impose geographic restrictions on personal or sensitive data. For example, European organizations may require customer data to remain within EU borders to comply with GDPR. Localization terms also define access boundaries, specifying that administrative access will occur only from authorized regions. Transfer mechanisms such as standard contractual clauses may be included to govern lawful movement when cross-border access is unavoidable. Data residency provisions resemble zoning laws. They dictate where certain activities may occur. In the cloud, such terms ensure compliance with privacy regulations and bolster customer confidence. Absent these commitments, data may flow through unexpected regions, exposing organizations to legal liability and regulatory sanctions. Residency clauses turn abstract compliance promises into concrete geographic guarantees. Security requirements clauses anchor contracts by referencing control frameworks and detailing technical expectations. These may include encryption standards, patching cadences, and vulnerability management practices. For instance, a clause might require encryption of all sensitive data at rest with AES 256 and mandate quarterly vulnerability scans. By referencing frameworks like ISO 27001 or NIST 800-53, Contracts link obligations to recognized benchmarks. This reduces ambiguity and allows for independent verification. Think of such clauses as building codes. They ensure not only that structures stand, but that they meet accepted safety standards. In cloud, where shared responsibility can blur boundaries, explicit security clauses clarify obligations. Customers must negotiate these carefully, ensuring that controls align with their regulatory requirements. Strong security requirements demonstrate that providers are not only technically capable, but also contractually accountable. Key custody clauses define who manages cryptographic keys protecting sensitive data. Options may include provider-managed keys, bring your own key, BYOK, or hold your own key, HYOK models. These clauses have profound implications for control and liability. In BYOK, customers generate and supply keys while providers manage usage. HYOK goes further, requiring that keys never leave customer-controlled hardware. Contracts must specify which model applies, as well as responsibilities for rotation, backup, and destruction. Key custody resembles safekeeping valuables. Do you trust a bank vault, or do you keep them in your own safe? Each model balances convenience, cost, and security differently. Clear clauses prevent disputes and ensure compliance with data protection laws. Without them, organizations risk misaligned expectations about who truly controls access to encrypted data in the cloud. Audit rights and evidence access provisions give customers visibility into provider operations. These may include rights to review society reports, conduct site visits, or receive independent assessments. Contracts often define cadence, scope, and limits to prevent disruption while ensuring meaningful oversight. For example, a customer may be entitled to one on-site audit per year supplemented by quarterly attestation reports. These clauses are critical for regulated industries, where organizations must demonstrate due diligence over service providers. Audit rights are like inspection rights for tenants. Landlords may maintain the building, but tenants must confirm it meets agreed standards. Without access rights, customers are forced to rely solely on provider assurances, which may not satisfy auditors or regulators. Properly crafted audit clauses ensure transparency without overwhelming providers, balancing oversight with operational practicality. Penetration testing and vulnerability disclosure clauses clarify how security testing can be conducted. Providers may restrict testing to defined windows, environments, or notification paths to prevent disruption. At the same time, customers or third-party testers must be assured they can assess provider security without violating terms of service. Vulnerability disclosure policies specify how researchers can report flaws responsibly and how providers must respond. These provisions are the legal equivalent of safety drills. They ensure vulnerabilities can be found and fixed in structured, cooperative ways. Absent clear terms, testing may be treated as unauthorized access, creating liability. Conversely, without disclosure processes, vulnerabilities may linger unreported. Penetration and disclosure clauses strike a balance between protecting infrastructure and encouraging responsible testing, reinforcing continuous improvement in security. Incident and breach notification clauses specify how and when providers must notify customers of security events. These include trigger thresholds, notification timelines, required content, and cooperation duties. For example, a contract may require notification within 24 hours of confirming a breach, including details of affected data and mitigation steps. Such clauses are vital because regulatory laws often impose strict deadlines, such as GDPR's 72-hour reporting requirement. Without contractual guarantees, customers may be left uninformed, unable to meet their own legal obligations. Incident notification resembles emergency alerts for natural disasters. Timely warnings allow affected parties to act. These clauses align provider practices with customer responsibilities, ensuring coordinated response. They also provide leverage, holding providers accountable for transparency in the face of adversity. Availability SLAs define measurable uptime commitments, often expressed as percentages. For instance, 99.9% uptime translates to less than 9 hours of annual downtime. SLAs also specify measurement windows, exclusions such as planned maintenance, and remedies like service credits. Availability clauses matter because they quantify reliability, turning vague promises into enforceable metrics. Imagine buying insurance where coverage is adequate versus defined at specific amounts. The difference is accountability. Availability SLAs also shape architectural decisions. Customers may design redundancy based on what the provider guarantees. Without clear SLAs, organizations cannot plan effectively or recover losses when outages exceed expectations. Properly negotiated, availability SLAs create alignment between business needs and provider commitments, ensuring resilience is not left to interpretation. Support and maintenance clauses define how providers will respond to issues. They may outline support tiers, response times, and escalation paths. For example, a critical outage may guarantee a response within 15 minutes, while low-priority tickets may receive responses within a day. These terms also cover planned downtime, patch schedules, and customer notification expectations. Support clauses resemble roadside assistance policies. They specify who to call, how quickly help arrives, and what services are included. Without defined terms, customers risk unpredictable delays or inadequate support. In cloud operations, where downtime can have cascading effects, reliable support is as crucial as system availability. Well-defined support clauses ensure that when incidents occur, response is timely, predictable, and aligned with customer priorities. Acceptable use policies and misuse clauses round out contracts by setting boundaries on how services may be used. These provisions prohibit activities such as spamming, cryptocurrency mining, or hosting illegal content. Violations may trigger suspension or termination of services. AUPs protect both the provider and the customer community, ensuring resources are not abused in ways that compromise reliability or reputation. They are similar to house rules in shared apartments. Freedoms are preserved only when tenants respect collective boundaries. For customers, understanding AUPs is critical, since violations, intentional or accidental, can lead to sudden service disruptions. Providers, in turn, must apply AUPs consistently and transparently to maintain trust. By codifying acceptable use, contracts ensure services are used responsibly, preserving stability across shared infrastructure. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Evidence deliverables give customers concrete artifacts to validate provider claims. Common deliverables include ISO certifications, SOC 1 or SOC 2 reports, and security white papers. These documents allow customers to confirm that controls are in place without performing their own redundant audits. For example, an ISO 27001 certificate demonstrates a provider's adherence to a recognized information security framework, while a SOC 2 report evaluates control effectiveness for confidentiality, integrity, and availability. Evidence deliverables act like report cards. They don't reveal every detail but provide a structured assurance baseline. Without them, customers would lack independent validation, relying solely on provider self-assertions. Including evidence deliverables in contracts ensures a predictable cadence of updates, such as annual reports or semi-annual attestations, giving customers ongoing confidence that commitments are sustained over time. These artifacts are vital for regulatory audits, compliance reporting, and board-level risk oversight. User Entity Control Considerations, often shortened to UECC, appear in society reports and highlight the customer's responsibilities for controls that providers cannot fulfill. For example, a society report may confirm that a provider enforces strong encryption, but note that customers must configure their applications correctly to benefit. UECCs remind customers that compliance is a shared exercise, not a service delivered unilaterally. Think of it like renting a car. The company ensures the brakes work, but the driver must still use them responsibly. By documenting these dependencies, SOC reports prevent false assumptions of complete coverage. Contracts referencing UECCs ensure customers acknowledge and implement their share of controls, making attestations reliable. Failing to act on UECCs can lead to gaps where provider evidence looks solid, but customer inaction undermines compliance. Recognizing these boundaries reinforces the shared responsibility model within formal audit contexts. Liability caps, exclusions, and indemnification clauses allocate financial risk between provider and customer. Liability caps limit the amount a provider may owe in damages, often tied to the value of services paid over a defined period. Exclusions remove certain risks altogether, such as consequential damages. Indemnification clauses determine who must cover costs when third-party claims arise, such as intellectual property disputes. These terms are the financial guardrails of cloud contracts, clarifying who pays when failures or disputes occur. For customers, negotiating liability caps is crucial to avoid disproportionate exposure. For providers, exclusions limit catastrophic risk from unpredictable scenarios. This balance resembles insurance deductibles. Protections exist, but within defined limits. Understanding liability language ensures both parties enter agreements with clear expectations, reducing the likelihood of contentious litigation and aligning financial accountability with operational responsibility. Cyber insurance provisions increasingly appear in contracts, requiring providers to carry coverage and provide proof. These requirements align contractual risk with financial protection. For example, a customer may demand evidence of cyber insurance that covers data breaches, business interruption, and regulatory fines. Coverage terms matter. Policies often exclude acts of war or nation-state attacks, meaning expectations must be realistic. Proof of coverage clauses ensure customers can review policies, verifying adequacy against potential exposures. Cyber insurance in contracts functions much like requiring builders to carry liability insurance. It doesn't prevent accidents but ensures financial remediation when they occur. For customers, these provisions provide an additional layer of assurance, while for providers, they demonstrate financial maturity. Integrating cyber insurance into agreements reflects recognition that no system is invulnerable, and financial recovery mechanisms are as critical as technical defenses. Service credit structures define the remedies available when SLA commitments are missed. Typically, providers offer credits against future bills, calculated based on the severity and duration of the outage. For example, a 99.9% uptime SLA may provide a 10% credit if exceeded by certain thresholds. However, contracts often specify that credits are the sole remedy, limiting customer recourse. Chronic failure provisions may escalate consequences, such as contract termination rights, if SLAs are repeatedly missed. These structures resemble warranties on appliances. Compensation is provided, but only within tightly defined boundaries. Customers must assess whether credits meaningfully offset business impacts or whether broader remedies are required. Negotiating service credit terms carefully ensures that SLAs are not symbolic but provide practical incentives for reliability. Strong credit frameworks also signal provider confidence in meeting their commitments consistently. Term, renewal, and termination assistance clauses govern the life cycle of the contractual relationship. These clauses specify contract length, automatic renewal processes, and conditions for early termination. Termination assistance provisions ensure that customers can migrate data and workload smoothly, often with defined timelines, fees, and support obligations. Without them, customers risk being locked in, unable to exit without disruption or excessive cost. Imagine renting an apartment where the lease ends, but the landlord controls how quickly you can move your belongings. Termination assistance prevents such dependency. Well-crafted clauses also cover transitional support, such as maintaining services for 90 days post-termination. Renewal clauses ensure pricing transparency and prevent unexpected increases. These lifecycle provisions give customers flexibility and security, ensuring contractual relationships remain balanced and transitions are manageable when they inevitably occur. Data return and deletion terms safeguard information when services end. Contracts must specify formats for data return, such as CSV exports, timelines for completion, associated fees, and requirements for certificates of destruction once data is deleted. These clauses ensure that sensitive information does not linger in provider systems longer than necessary. They also establish accountability for secure erasure, which is vital for compliance with privacy regulations like GDPR. Picture moving out of a rented office. You not only take your files but also verify that no confidential documents remain in the building. Data return and deletion clauses provide the digital equivalent of this assurance. Without them, customers may face uncertainty about whether data remains recoverable by providers, exposing them to regulatory penalties or ongoing risks. Strong contractual terms close the lifecycle loop responsibly and defensibly. Intellectual property and licensing terms clarify ownership of custom work, derivative products, and use of open-source components. For example, if a provider develops custom automation for a customer, the contract must define whether ownership lies with the customer, the provider, or is jointly shared. Licensing terms cover rights to use proprietary tools, restrictions on distribution, and obligations to comply with open-source licenses. These clauses prevent disputes over who controls innovations created during service delivery. It is like co-writing a book. Contracts must state who owns the copyright and who may publish it. Clear terms reduce ambiguity, protect creativity, and align expectations. They also ensure compliance with external obligations, such as maintaining attribution for open-source software. In cloud, intellectual property rights are central to avoiding conflicts and ensuring both innovation and fairness. Compliance change and regulatory update clauses anticipate that laws and standards evolve. These provisions specify how provider and customer responsibilities adapt when new regulations, such as data residency laws or AI governance frameworks, take effect. Without such clauses, contracts may become outdated, leaving compliance gaps. For example, if a new privacy law requires data processing changes, the contract may obligate the provider to update services or notify customers of limitations. These clauses resemble maintenance agreements for vehicles. As road rules change, vehicles must be updated to comply. Including regulatory update terms demonstrates maturity, ensuring that cloud services remain lawful over time. They also reduce disputes by clarifying adaptation responsibilities up front. In fast-moving environments, these clauses ensure contracts remain living instruments rather than static documents frozen in past legal contexts. Force majeure and disaster recovery terms address resilience in the face of extraordinary events. Force majeure relieves parties from liability when unforeseeable circumstances, such as natural disasters, wars, or pandemics, make performance impossible. Disaster recovery clauses go further, specifying expectations for recovery time and recovery point objectives. For example, a provider may commit to restoring services within 4 hours after a regional outage. These terms balance fairness with responsibility. While no provider can prevent earthquakes, they can plan for recovery. Customers must evaluate whether contractual commitments align with their business continuity needs. Force majeure is like insurance disclaimers protecting providers from events outside their control, while disaster recovery terms reassure customers that plans exist to resume operations promptly. Together, they ensure resilience is both acknowledged and structured in contractual form. Escalation and governance forums provide structured processes for ongoing contract management. These provisions establish regular reviews, scorecards, and issue resolution paths. For instance, a quarterly governance meeting may review SLA performance, outstanding issues, and planned changes. Escalation paths define how disputes rise through management tiers, ensuring problems are addressed before litigation. This governance structure resembles corporate board meetings. They create accountability, visibility, and shared decision-making. Without such forums, issues may fester, leaving dissatisfaction unaddressed. Strong governance clauses ensure the contract is not filed away, but actively managed throughout its life cycle. They promote collaboration rather than confrontation, building trust between provider and customer. Escalation and governance forums are critical for long-term partnerships, enabling adaptation and continuous improvement without constant renegotiation. Price protection, indexing, and usage audit clauses ensure transparency and predictability in costs. Price protection may freeze rates for a fixed period, while indexing ties costs to external measures such as inflation rates. Usage audits allow customers to verify billed consumption against actual resource use, preventing overcharges. For example, a contract might allow annual reviews of usage metrics to ensure accuracy. These provisions are akin to mortgage terms. Knowing rates and adjustment mechanisms allows for informed financial planning. Without them, customers may face unexpected increases or disputes over billing accuracy. Including clear price terms supports budget stability and reduces the likelihood of conflict. It also provides assurance to boards and investors that cloud costs remain controlled and verifiable, reinforcing trust in financial stewardship. Assignment, jurisdiction, and dispute resolution clauses establish the legal framework for contract interpretation and enforcement. Assignment terms govern whether rights or obligations can be transferred to other entities, such as in mergers or acquisitions. Jurisdiction clauses determine which laws govern the agreement, while dispute resolution provisions outline whether arbitration, mediation, or court proceedings apply. These terms prevent uncertainty when conflicts arise, ensuring both parties know where and how disputes will be handled. For example, a contract may specify New York law with arbitration in London. Without such clarity, disputes can become bogged down in competing claims of venue or procedure. These clauses act like maps. They define the terrain on which disagreements will be resolved. By including them, contracts anticipate conflict and provide a structured path for resolution. Anti-corruption, sanctions, and export control clauses ensure lawful operations across geographies. These provisions require both parties to comply with international trade laws, avoid dealings with sanctioned entities, and prevent bribery or corruption. In cloud, where services may span multiple jurisdictions, these obligations are essential. For instance, a provider may prohibit data hosting in embargoed countries, or require customers to comply with export control restrictions on encryption technologies. These clauses resemble codes of conduct. They reinforce that business must be conducted ethically and lawfully, regardless of local practices. Including them protects both parties from legal penalties and reputational harm. They also demonstrate a commitment to global responsibility, aligning cloud services with broader societal expectations. Anti-corruption and sanctions clauses elevate contracts beyond technical performance, embedding ethical guardrails into business relationships. From an exam perspective, candidates should focus on mapping contractual clauses to outcomes in security, privacy, audit, and operations. Questions may present scenarios such as data residency disputes, missed SLA targets, or unclear breach notification timelines, asking which clause applies. Success depends on understanding how legal instruments translate into enforceable commitments. For instance, recognizing that a DPA defines data controller processor roles, or that audit rights allow access to SOC reports, demonstrates applied knowledge. Exam relevance emphasizes not memorizing contract jargon, but reasoning about how clauses allocate responsibility and create evidence for assurance. By mastering these mappings, candidates show they can translate compliance requirements into operational safeguards, a skill vital for real-world cloud governance. Exam readiness here mirrors professional readiness. Contracts and SLAs are practical tools, not theoretical concepts. In conclusion, well-crafted contracts and SLAs transform broad promises of security and privacy into enforceable, measurable obligations. They define remedies, evidence rights, and operational boundaries with precision, ensuring accountability. Clauses addressing confidentiality, data processing, security requirements, and audit access give customers transparency and recourse. Terms governing liability, insurance, disaster recovery, and governance ensure resilience and financial balance. Anti-corruption and regulatory change clauses extend protections into ethics and adaptability. Together, these provisions form the backbone of cloud trust legal scaffolding that supports technical operations. Without them, organizations would face uncertainty, disputes, and compliance failures. With them, cloud services become not only technically reliable, but also contractually accountable. This alignment between law and operations sustains confidence, making contracts and SLAs central pillars of responsible cloud adoption and exam preparation alike. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.